All right, this one is going to be a audit. This is a brand new auditor, News Now Cleveland. He's still going through a rough patch, filming sideways, but cut him some slack. I did far worse. Some people are born to be auditors. Some people have to work at it. Anyway, he went to a federal courthouse. Doesn't understand why the 2010 DHS memo doesn't apply. It is a GSA building, so you'd think it would, but no, it doesn't, and he doesn't understand it. Well, let's look at the rule that 2010 DHS memo and the updated 2018 memo. First of all, both of those only apply to the FPS, but we've gone over that. But let's see in this situation why it wouldn't apply to this particular courthouse. Except where security regulations, rules, orders, or directives apply, or a federal court order or rule prohibits it. That's problem number one. There may be it's a federal courthouse. There's going to be a federal court order or rule that prohibits it. Persons entering in or on federal property may take photographs of space occupied by a tenant agency for non-commercial purposes only with the permission of the occupying agency concerned. The federal courthouse occupies that space. Therefore, and then the other space is the U.S. Marshals, and I think a U.S. Custom, or there was another U.S. agency in there, but you have to get the permission of one of them to do it. But the big problem you're going to run into is the federal court order or rule that prohibits it. Now, ooh, I got a new subscriber. Welcome, Torker. You get a shout out for subscribing while I'm recording this. So these are the local rules for these are the local civil rules for the Northern District of Ohio, which is where he's filming. And so I don't go to any other state, and honestly, I haven't done anything in front of a federal court yet, so take this with a grain of salt. But in California, there's the California rules of court, and then there's the California local rules of court. And looking into the California and Texas rules, I have found there are also local rules for the federal districts in California and Texas, because California and Texas have multiple districts. They're not just a single district for the entire state. And don't confuse circuit with district, because the Ninth Circuit has a lot of districts in it. Anyway, so there are local rules, and one of the local rules, this is from the Civil Rules 83.1. Let me show you where I clicked it so you know that I actually found it here. 83.1, it's this right here. And that brought me to here. The taking of photographs in the courtroom or its environs. And environs are described as including certain property of the United States in the Northern District of Ohio, to wit, and then they list buildings, and they say also included in these definitions are the buildings and all driveways and entrances into and exits from said buildings, as well as the offices of the clerk of court, probation offices, pretrial services, and offices of the United States Marshal, and all corridors, offices, rooms, and other areas within those buildings. Not included within the definition of environs are the sidewalks adjacent to said buildings and a press room. Oh, and then they also have an exemption for proceedings other than judicial proceedings designed and conducted as ceremonies, such as administering oaths of office, etc. They can be photographed. The reason why they excluded the sidewalks is U.S. v. Grace, where the Supreme Court invalidated a 40 U.S.C. Section 13K. They said, as applied to the public sidewalk surrounding the court building, it's unconstitutional under the First Amendment. They alluded to it probably being constitutional, but they didn't have to address that. And they said that the court would likely be considered a limited public forum. So bans like this are probably constitutional. You may not like it, but you got to separate what you don't like from what is or isn't constitutional. And what is or isn't constitutional is not what you think should be or shouldn't be constitutional. It's what the Supreme Court thinks, mainly, first and foremost. And then if the Supreme Court hasn't voiced an opinion on it, then it's what federal appeals courts think. And if they haven't voiced an opinion on it, then it's what federal district courts think. It's not what you think that matters. It's what the courts think. So, yeah, so US v. Grace says that they can't control what goes on the sidewalk. So the officer apparently talked to the head judge, and this U.S. Marshal said that he'd be okay with letting the auditor film outside anywhere he wanted. So they could have, by the letter of the enforcement mechanism, by the rule, they could have prevented him from filming even there in the courtyard. But they didn't prevent him from it. So I would take that as a win. You are free to differ. But anyway, give News Now Cleveland a sub. He went out and did it. He's mistaken as to the matters of law, but he sees something that he thinks he should do, and he's being active, and, go get him, Tiger. His comment section isn't the brightest. This gentleman says that judges can only set policy for inside the courtroom. The rest of the building is free game, and judges' policy does not trump law. You could try, but you would be explaining that to the judge from the other side of bars, so I don't think you'd get too far. Mr. Bushman, who is a well-meaning fellow, I think, but he does not give sage legal advice, ever, says court orders only apply to those who have been served by them. That is not true. Where is the court order? It's a rule, but that's fine. I showed it to you. You could have looked it up yourself. But I understand that sometimes these things, unless you know what to look for, I understand that they can be hard to find. Without due process, the court order does not apply. That is not true. Court orders and court rules may apply even without due process. Say, for example, one person wants to dig up an Indian burial ground, and the tribe takes him to court to get an injunction against anybody disturbing that Indian burial ground. And let's say the court grants it, or maybe just a temporary. Maybe it's just a temporary injunction on anybody digging up that Indian burial ground. Then it would literally prevent even people who aren't parties to that suit from doing it. Yes, the court order can do it. So show me where it says they can't. Because I've seen them do it, and it works. And you get popped for contempt if you try to fight it. So, and he says orders are given to people, not places. No, like I said, they could put an injunction on digging up an Indian burial ground. They could put an injunction on building a building, or tearing down a building, or cutting down a tree. It would apply to the tree, and anybody who cut the tree down would be subject to contempt proceedings. So, yeah. Anyway, be careful of bad advice and comments. Anyway, I've rambled long enough. Happy Friday. Thanks for watching. Yeah, and sub News Now Cleveland. Have a great day.